Thank you all for having me here. It's always a pleasure to come back and see everyone in flesh. So great to be here again. And I'm looking forward to the schoolyard course in a minute. It brings so many memories. And thank you for inviting me, for having me to this very important project, and for giving me an opportunity to discuss what would be indeed an intersection of my bigger research design with this EU concerns related to what could be called legal management or legal governance of abortion. So Florence has very kindly mentioned that what I'm going to say will be actually an installment of a project that's only just started. So it started on the 1st of October last year. So I'm really going, as I've already mentioned to Sophie, I will have more to say about what will be done than about what has been done already. Nonetheless, as a part of the preparatory work, some things have been done regarding the abortion discourses in the EU legal space. So my talk will be actually divided into three parts, and it will be, I hope, a combination of this legal pillar of the of abortion-related considerations with this more sociological and even anthropological concerns related to it. So I will start with the legal side of the problem, let's call it that way, and then I will move to what is called in the title of my talk the figurational aspects, and I will end on the rather lofty cultural note. And hopefully I will manage to do that all in under 30 minutes. I was thinking about under 30 minutes. So it is, well, it has become a cliche that abortion law and general reproductive rights have become a very important vital area of contention all over the world, but especially in Europe recently. And in the scholarship, there has been an argument made repeatedly that what seemed to have been a rise in the liberalization of abortion law worldwide has now come to a halt, and then instead of what could be seen as a broad global trend of legal and social and cultural change is instead replaced by a growing sense of contention, conflict, and disagreement about the legal governance of abortion, but also about the cultural symbolic meaning of abortion as a medical procedure, as a kind of choice that a person is making about their lives, and also about a phenomenon that has its place in the cultural historical landscape of societies all over the world. I will not, of course, cover all that. I will just focus on how the European Union has found itself in this very broad and complicated nexus of issues related to governance of abortion. Now, the position, and this is the first part, so the legal side. The position of the EU in this matter is extremely difficult. Why is that? On the one hand, well, the EU is commonly associated with this most advanced, best part of the world, where life is best, well, apart from strange places like Canada, maybe. So where people are living good, when women's rights are respected, when there is general consensus about equality, gender diversity, and so on. I'm sure Sophie will have much to add to that point. So this does not exactly coincide with the reality of the European countries in the field of abortion access, abortion regulation, and also these imaginaries, legal imaginaries related to abortion. And while abortion is allowed in the majority of the EU member states, vast majority of those, and also it is allowed with different gestational periods, and of course, and it's also subject to various legal constraints regarding medical opinions and the kind of consultations that pregnant persons have to go through before undergoing abortion. There are also countries where abortion is prohibited, and there are also countries where abortion laws are heading towards more restrictive regulations, to which I will come back in a second. So there is actually no European standard on abortion. That would be my argument, first of all, even though, as said, majority of EU countries do allow abortions under various circumstances to various extents. Then the EU as an organization does not regulate this matter directly. And it is, again, a very important thing. So if we are thinking about the EU legal space as a space of standardization, then abortion regulation is not part of that. And it is crucial for the understanding how the EU goes about this subject, which will be actually what I'm going to discuss now. There are many links that the EU can make, so to say, to the legal regulation of abortion. The most important link are absolutely the human rights. This is the link that's always brought up, that always reoccurs in the European EU discussions about abortion law, and I will demonstrate how this link works in a minute using the resolutions of the European Parliament on abortion. But this is not the only link. Of course, the human rights links works through the Council of Europe, through the Charter of Fundamental Rights, and it works through the endorsement, so to say, of the European Court of Human Rights jurisprudence on human rights, including reproductive rights, including abortion regulation, by the European Union. So it's a double-headed structure, and it's very important that this double-headed structure would normally sometimes seem like a one-headed structure, no conflict, no problem. But in matters of abortion, it's not necessarily the case. Then there is also a human rights link further from home, so through the United Nations jurisprudential bodies, especially the Committee of Human Rights. And there is also another jurisprudential link, and I think it's much under-analyzed in the scholarship. This is the Court of Justice of the European Union jurisprudence, is also relevant for this matter. So there are links despite the lack of direct regulation, and there are also triggers. There are some very important triggers, these moments when the EU reacts to abortion-related matters. Accession of new countries is one very important trigger. This trigger was put in force in 2002 for Malta and also for Poland. There was an appeal from the European Parliament. This is just an example of how a trigger works. It's a combination of political and legal action to liberalize their abortion laws, and the countries reacted with additional protocols in order to defend themselves against what they saw as a cultural imposition on the part of the EU, and then acting, extra vires in this very broad sense of the word. There are also triggers coming from the Court of Justice of the European Union cases incited by the situations arising in countries with with restrictive abortion law. And the most important example probably is Grogan against the CPUC, which is, it's spook. If you read it, it's spook. I cannot help just being amused by this coincidence, like very phonetic coincidence. So in this case of 1991, the Court of Justice discussed the issue of whether abortion is a service. And it's very symptomatic. So you cannot, the facts of the case were that students were distributing in Ireland leaflets regarding abortion services being provided in other member states by fully legit abortion facilities. And the Irish court issued a legal question regarding the legality of this action in the light of the EU law. And that's how the Court of Justice came to consider whether abortion can be thought of as service in the sense of freedom to provide services in the European Union, and it decided that it could. It could be. I have a quote here, but it's a very long one, so I won't read it. Which did not really change anything in the situation of the students, because it turned out that they did not have a legal link to these abortion facilities. Therefore, they could not have been seen as commercial agents for these facilities, so to say, so that this was not really the provision of services in the sense of the treaties. It's a very interesting judgment, and I think, well, it would definitely deserve more attention, analytically speaking. So this is another trigger. There is also a broad trigger of the European Court of Justice jurisprudence, especially, again, coming from countries with very restrictive laws. And there are a few milestone cases, or we would call them landmark cases probably. VO versus France and AB and CV Ireland. That latter is very important because this is where the concept of a very broad margin of appreciation, so a very broad freedom to decide on matters of abortion, to put it bluntly, was really petrified by the court. And this is where we stand. There is also the negotiation of new treaties. And the discussion came up again, of course, at the opportunity of the Charter of Fundamental Rights. This was where the debate on abortion in the EU was very hectic. There are, again, developments in the member states. The Polish, what the European Parliament calls a near ban of abortion in 2020, caused a lot of discussion in the EU, and I will come to the more tangible results of it right away. There is also Hungarian legislation of 2022. This was the legislation that required, September 2002, that required a pregnant person, a pregnant woman, to listen to the heartbeat of the fetus before making a decision on abortion. And this is a fascinating case of how the EU institutions go around abortion problems, and I will come to that in a second. And there was also a powerful trigger, somewhat unexpected. For me, it was a surprise, really. And this was, of course, Dobbs v. Jackson's Women's Health Organization, so what is commonly referred to as overturning of Roe v. Wade in the US. Surprisingly enough, the EU also reacted to it in a very significant manner. When I say EU now, what do I mean? I basically mean the European Parliament, because this is the body that reacts to things. Sorry to put it that crudely, but whereas the European Commission and the Council, well, typically say that there is nothing to be done and that there is nothing beyond the expression of personal standpoints of individual members of these bodies and the re-endorsement of the official division of powers between member states and the community or the union, the European Parliament does express wishes for a change, it does express views, opinions, and it does react to what could be said, could be called public and societal discourses on abortion. That's why I find, and I think that now it might be a good moment to launch the handout. Sorry, we did try to do it from my computer, but it wouldn't work. I'm sure it's just some kind of a technical problem of mine.
This is...
Yeah, so if we might start with page 1 now. Yeah, and number 1. Exactly. So this is the handout, and this is also the handout that you will all receive from Teresa or from Denis after the meeting, so that you might just have a look at it afterwards.
Okay.
Okay, and I will just point your attention, draw your attention. Sorry.
No, sorry, it's my.
Oh, I will do the introduction.
Just,
you know.
Yes, do the introduction, and I share the screen. Okay.
So I will just draw your attention to 5 resolutions, and this will also be illustrative of the way that I intend to proceed, or we intend to proceed in the ERC Consolidator project that Florence was kind enough to mention in her introduction. So this project is actually a comparison or a comparative analysis of how human rights are used as an argument for changing abortion law in whatever direction. And it's very important because human rights are not only used as an argument by the so-called pro-choice circles and advocacy organizations, but also by the pro-life ones. So it's equally relevant to look at all these uses of human rights in order to get to the understanding of the current conflict around abortion regulation from this angle. So in the project, we'll be looking at this language of human rights in action, in law and also in public discourses, in societal discourses in 6 countries of the world that have been chosen to represent 3 human rights systems. So the European one, the African one, and the Inter-American one. So we'll be looking at Poland and Ireland for Europe, at Honduras and Argentina for the Americas, and at Mozambique and Senegal for Africa. And for each system, 2 countries were chosen that have very conflicting abortion laws going in opposite directions, at least, well, on paper, as far as de lege lata, as lawyers would say. And this thing that we'll be seeing here is a very small fraction of what could be seen as an insight into the language used by the European lawmaker, by the European Parliament, when thinking about abortion. And it shows, I would argue, a change, a conceptual change that's been taking place over very few years, actually less than 2 years, if you think about it. So we have 5 resolutions that I will talk about. One of them, 2 of them are on Poland. One of them was adopted apropos the de facto ban of right abortion to Poland. Then there was the anniversary of that happening, and again a resolution followed. 2 of them relate to the American circumstances. So first of all, to the Texas law on abortion, then on the potential decision of the Supreme Court, and after the decision was taken to the decision of the Supreme Court on, so there will be 3 altogether. And then there is also one that relates to Hungary. We'll see whether I have time enough to get to that, because its discursive framing was extremely interesting. And now, if you look at the resolution, first of all, this is the one on Poland. You see that the mention in the C letter, I'm sure most of you will be familiar with how these documents are construed. So first there are these general things to think about. Then there are these where the things that the European Parliament thinks that need to be done, and there is plenty of considerations that are hidden between the 2 structural parts of this document. So they really deserve close reading. And it's also very sensible that these are products of political negotiation. So there are various fractions trying to put things into the resolutions, and what comes up is also discursively seen not a very coherent structure from time to time, which of course opens the way for interesting interpretations, or hopefully interesting interpretations. So if you see it, this C whereas in this first resolution, so you have equal treatment and non-discrimination, and it's the single most important framework where the EU can attack the issue of abortion, the way I see it. Because this is indeed an issue that is enshrined, as we can read here, in the treaties and the Charter. Reproductive rights are not enshrined anywhere in the Charter. Or if they are, they're only very indirectly. Whereas equal treatment and non-discrimination, that is indeed a good reference. Then there you have the very general reference, and it's judiciously phrased. So according to the Charter, the ECHR and the case law of the same, and these rights are related to multiple human rights. And they are also reflected in the Polish constitution. And then look at at number 4. Women's rights are fundamental human rights. So are they related to human rights, or are they human rights? I think it does show a kind of a confusion that we're going through here. Whereas in letter G, you have this very open and radical formulation of the position of the Parliament, their body, their choice. How does it all hang together? And then in number 20, we read that the Commission should support member states in guaranteeing universal access to sexual and reproductive health services, including abortion. This is a point repeatedly made by the Parliament, but maybe it's just a sociologist reading it, but how can you support somebody in doing something they don't want to do? Because they are discussing a state that does not want to do that. It's not support that is being called for here. So this is the first resolution, and then you can also, regarding this point, mention one other thing. I didn't choose any textual illustration for that. This resolution is a mix of matters related to abortion law and to Polish constitutional order and the rule of law. Because, of course, as we are all aware, Poland has this huge rule of law problem that's getting deeper and deeper. And in this resolution, it's almost like 1 point on the rule of law, 1 point on reproductive rights. 1 point of rule of law, 1 point on reproductive rights. The 2 are interwoven, and they are indeed, legally speaking, conceptually speaking, interwoven. They do condition each other. There is a legal link between the 2, but this link is not really made very clear in this resolution. Then, we might move to point 2 now. Thank you. On the anniversary of the same judgment of Polish Constitutional Tribunal, it's second page. I divided it in between pages, so the scrolling would.
And I have to. Sorry. No, not yet.
Not yet. Not yet. But in a second.
It's technical issues.
No, not really. I mean,
Yes.
there is one important addition there anyway. So there is an addition to the.
Easier this way. Okay.
Okay, great. Which is also marked in bold, the inclusion of the jurisprudence of the United Nations treaty bodies. As though somebody just remembered there was some. And there was also a call on the Commission to support the member state in guaranteeing access to sexual and reproductive health services and include rights and services, including access to safe and legal abortion for all citizens. Why is it important? Because it was usually about women and girls. This is the language that also prevails in the United Nations documents. So this is always about women and girls and their rights. Here, we have a turn towards all citizens, so towards a universalization of the issue. For me, and it's a point that I have discussed with Emilia recently, so I know it's a point that can be contested. But in this debate, you can clearly see the difficulty in thinking about abortion as a part of reproductive rights agenda in terms of something that concerns everyone, not just those who can get pregnant, which are usually women in terms of gender. So this is one interesting thing that I wanted to stress here. And then you have the point about services coming back. So as though somebody remembered, okay, there was Grogan, so let's have it. And there is also a call regarding the Istanbul Convention about the need of the directive on gender-based violence. So this is the human rights framing here. It is first of all an attempt to universalize it and then to relate it to gender-based violence. This is indeed the case in much of the European Court of Human Rights jurisprudence. So now we might move towards the first American one. And this is, you know, this is frantically interesting how the EU engages with the US. Because you know that there is so much expertise both ways. So these people definitely know how this works. Still, there is this anthropological estrangement with how they are writing. And in this third point, why this appears here, that engaging men and boys is a very important goal here. So another attempt to universalize, this time gender addressing attempt to universalize it by getting men and boys interested for the issue, in the issue. And then there is in the number 9, section 9, it is a very interesting call on the United States government to fully decriminalize abortion, etc., by doing all these things, including removing abortion from criminal law statutes and abolishing all other punitive laws, policies, and practices. Why is it so frantically interesting? Because abortion is in criminal laws all over Europe still, including Germany, for example. Like, you know, this pillar country of European, so to say, identity building, for lack of other words. So I do not recall a similar call being issued on all these, you know, named European countries. This is definitely an effect of this happening elsewhere. This would be my reading. And then there is another American one, number 4. And you can see, thank you, this is only 1.17. This is this globalizing agenda. So there is a mention of what is happening in the same sphere of regulation all over the world. And I think it's interesting because of what countries are mentioned, how they are ordered. So South America is definitely seen as a cluster of countries here as opposed to other countries. And of course it would be very difficult to see, for example, African countries as a cluster in any way, in that sense. But it's also something that's not said here, even though it's mentioned a lot in these resolutions. These resolutions have a lot to say on the implementation of abortion regulation. In these countries, the implementation standards are very, very diverse, despite the legislation that is in the line with the liberalizing tendency that the European Parliament actually postulates here. The implementation is not mentioned here. So this is definitely a way to inscribe the EU agenda into a broader global framework. And there is the final one then. This will be the next page. Yeah. Smooth way. And this is, of course, one that we have all, I'm certain, read about. When the US Supreme Court decided to overturn Roe v. Wade and decided in Dobbs that abortion is not a matter that's enshrined in the federal constitution, the European legislators reacted by, this is a very, again, it's a significant way to say it, because two countries are named and two highly mediatized cases are named here. The case of the American tourist that almost died in Malta, and the case of a Polish activist that's still being, has to face court proceedings for her aiding and abetting abortion, as it was construed, even though it was the first case for an activist to be so charged. Not a doctor, not a medical service provider, but an activist. But what is this is the human interest angle that's so very clearly mobilized here, and it leads to a very radical proposition that was also highly mediatized. The proposition to include the right to abortion in the charter, so to amend the charter in order to have and we need this final line here because it's, yeah, again, and it's the right for everyone, not for women and girls. It's a right for everyone. So it's, again, the move towards universalizing the right to abortion. And it's also what I should call a move from binary language of addressing abortion and reproductive rights to a different way of addressing them, which I would personally see as more inclusive for a number of reasons. So there is, what will happen then? What can happen afterwards? Well, this is a very interesting question. We have seen with the recent developments in France, for example, that there is a move towards constitutionalization of abortion law in some countries. There is also a great opposition against endorsing abortion rights in some other countries, including Malta, and including my home country, Poland, and many other countries too. The reaction there from that, I think I have time to mention that. The reaction from that point of view to the Hungarian case was very interesting. The Hungarian case that I've already mentioned, the amendment of the abortion law, amendment that could, on the one hand, be seen as a slight amendment. It was in no way comparable to what happened in Poland, to really an effective ban of abortion. On the other hand, it is a kind of amendment that points out to a philosophical difficulty in regulating abortion by introducing the heartbeat of the fetus as a factor. And in Hungarian media and in many other, especially right-wing and conservative media, there was a widely discussed concept that the European Parliament adopting 2 days later, I think, than the Hungarian law was written into force, a resolution stating that Hungary is no longer a democracy, that it is in fact a democracy at risk, that this is it does not no longer fulfill the democratic standards, in fact reacted to that law. I have examined this resolution. It does not mention it expressly, even though it does mention women and girls' situation, especially the Roma women and girls' situation in Hungary, which is deplorable. But it is a political reaction, and it was so read. So this is another way of going around the issue, possibly, if this reading can in fact be upheld, and to attack the right to abortion as a part of the democratic agenda, of the EU democratic agenda, and the rule of law agenda, and the cases of Hungary and Poland provide material for analyzing it that way. And of course, there is, and this is my point too, figurational logic behind it. And I'm using the word figuration as a term coming from Norbert Elias, the sociologist, whose theory will be one of the major points of departure for the study in this ERC project and also for this talk. And what the figuration is, broadly speaking, it is a dynamic setup of positions that differ in access of power, in access to power, that are characterized by varying power differentials, as it's usually translated. So in this situation that I have just described and illustrated with these 5 sets of quotes, you can clearly see that there is a difference between the global, the regional, and the national structures. The global, the regional, and the national level of integration, as Elias would put it. There is the global reference to other countries far away, other structures with different legal systems. There is the regional structure of Council of Europe plus the European Union. And there are also these nation states that are so very puzzling with their very differing ideas about the regulation of abortion. There is also clearly, or even though it might not have been seen in these quotes, a competition between the institutions, a competition in how they think about these matters. The trend nowadays would be that the United Nations are clearer and their position on abortion is getting less and less ambiguous over time. The African system has been more pronounced on the right to abortion as human right, and other institutions are somewhere in between, moving but not always consistently in the same directions. There is also a race of liberalization versus the race of restriction. So there is no longer one trend and one race, as I have mentioned. Mm-hmm. There is, in fact, also a conservative race of more restriction as a point of aspiration. This is very important. And if you read, for example, the post on the European Center for Law and Justice, this is an organization that advocates a more restrictive approach to abortion. Or if you, that's something I mentioned today to Sophie, or if you read the reactions to the European Parliament resolutions, there is a pattern there. So there is a resolution and there will be a conservative organization filing for the annulment of this resolution on grounds of it being not in conformity with the European values. These are normally declined. Now, somebody has to pay for them, of course, but they are there. They are being resubmitted. So there is an active contention going on. This is a clear case of contentious politics taking place in the core of the institutions. This is not social movements. This is not social movements only that we're discussing here. This is institutionalized policy making. This is, of course, supported by these global rankings that we have all seen and by all these visualization strategies that I will not get into right now. And a number of correlating issues come into that reinforce the figurational logic of contention, competition, and racing. These correlating issues would be other women's rights, other than reproductive rights. They would mostly be related to gender equality that crystallizes in the women's position. The issue of gender-based violence, that's another self-standing point that gets related to abortion, as I have shown. And there would be the rights of LGBTQI plus people. This is a connection that might be somehow surprising if we consider the developmental paths of feminist theory on the one hand and query on the other hand. But they coincide in this contentious politics because they have a common enemy. That would be also my argument, but it would take more time to substantiate that. I would be happy to do so in the Q&A. So where does the EU stand? Figurationally speaking, the situation is forcing the EU's hand. This would seem so. But abortion is such a hugely divisive matter that it's hard to say whether the centripetal or centrifugal forces will prevail within the organization. Just as it is difficult to say how the global figuration of human rights, the capped by the United Nations, will react to this divisive effects and whether the centrifugal forces will not in fact prevail. This small quote on Latin America. Latin America is today in the center of abortion law debates, whatever we might want to think about it in Europe. And whether this will also lead to some kind of legal shifts of weights with Latin America and the EU on the one hand, and the US and the global conservative networks, including Muslim conservative networks, on the other hand, well, this would be a fascinating turn of the case. I'm not sure whether this is going to happen. A lot depends on what happens in the United States, of course. But this would be the very broadly speaking figurational logic of this. And there is also, and this is the final point, a very, very small one, the cultural logic behind it. So human rights, including reproductive rights, has been a part of these aspirational structures that have been accepted and endorsed in many countries of the world, including the region where I come from, the Central and Eastern post-socialist Europe. So getting to Europe was at the same time getting to join the EU, getting to join the Council of Europe, and getting to apply the human rights standards that were associated with these organizations and with this region of Western Europe. This aspirational structure seems to be maybe not falling apart, but seems to be shaking a bit nowadays in Poland and in Hungary, certainly. These are the two countries at which I've been looking more carefully. And this affects the meanings of human rights that are constructed in these shaky discourses. These meanings are getting less and less coherent. This would be my central thesis. They are getting more and more contested, and the usage of human rights in abortion debates shows that there is less and less understanding between how various parties to the debate are using them, how they refer to them, what references they seek, and how they formulate, they postulate based on human rights argumentation. So there is, of course, a possibility that the EU will stay with this goods and services kind of a logic and will never attack the project problem directly. I don't think it's very likely. I think a very, very important stimulus now for the future will come from the European Court of Human Rights. Last year, the court has notified 12 new cases to Polish government, and these cases all come from after the abortion judgment. So there is a good possibility that it will be at the tipping point for the jurisprudence of the court. A possibility, still not a certainty, because all of these cases, in fact, concern access to legal abortion. So how the procedures were conducted. But this is a possibility. I think that avoidance could be a very big problem for the EU law for one reason. We have seen this going around the problem in the Parliament resolutions, and there is more going around the problem in the Commission statements and in the statements by individual EU officials. And this has a delegitimizing effect. So we are standing at the point where we are facing potential open conflict about abortion because it is a contentious matter versus a delegitimizing effect of adopting smoke and mirrors strategies by the European Union institutions. It's between a rock and a hard place, so to say. So with this very pessimistic observation, I will now end my talk, and I'm looking forward to all your suggestions for how this could be approached when I'm in the wrong and when what I should look at to make it more convincing and stronger. Thank you very much.
Thank you. Thank you very much, Marta.